just as a preliminary matter, I'm having some issues with internet this morning, and so my audio is coming through my phone. If I freeze, I am still able to listen and participate in the proceedings. Okay? So in the event that occurs, just know that we're going to just move forward because the audio is coming in through my telephone, not through the computer. Okay? So
Sounds
we are,
good.
all right, excellent. So welcome to the First District Court of Appeals. This is Tuesday, February 1st. We have one case for oral arguments this morning, and it is case Louise Bayless by and through her husband and next friend Stephen Bayless et al. Versus Durrani et al. Case number C190502. If parties can please identify themselves and their readiness to proceed.
Good morning, Your Honor. Bob Winter on behalf of the appellant Crystal Garrison, the administratrix of Louise Bayless, and we are prepared to proceed.
Good morning. Thank you.
Good morning, Your Honors. Jennifer Mitchell on behalf of the Christ Hospital. I believe she's actually the administratrix of Billy Spivey, not Louise Bayless. So I just wanted to correct the record in that regard.
That's correct,
Okay.
Your Honor. I agree.
All righty. Well, for some reason, this is how it's showing up on our docket. Thank you for the correction. Attorney Winter, would you like to reserve some time?
5 minutes, Your Honor.
5 minutes. Whenever you're ready.
Good morning, judges. As I've indicated, Bob Winter on behalf of Crystal Garrison, administratrix. The issue before us today is whether or not defendant Christ Hospital voluntarily submitted itself to the trial court's jurisdiction or committed other acts that constitute a waiver of the jurisdictional defense.
Well, I think before we get there,
yes,
because, you know, if under the civil rules, you've got the 6-month period, and you got a 1-year period. And the question I have is, did the defendant avail themselves to the proceedings within that 1 year or outside of that year, and does it matter?
I think that the acts that I've briefed and will briefly discuss today occurred outside the 1 year, beyond the 1 year. But I don't think it matters. And here's why. The complaint, I believe the record will show the complaint was filed on May 2nd of 2016. There was a deposition was noticed by my colleagues, plaintiff's counsel below for a physician witness. Christ Hospital's attorney was noticed. It did not notice the deposition, but it took the deposition. It participated in the proceedings. I noticed that the trial court thought that there was some importance that Christ Hospital did not dive into the specifics of this case. On the other hand, I submit that Ms. Mitchell got in at page 240 of the transcript and probably didn't need to ask any more specific questions.
The deposition that you're talking about was noticed for multiple plaintiffs' cases, right?
Yes.
And so the Christ Hospital was actually served for those cases, the other cases.
Yes.
And so they kind of had to show up to defend the depot, right?
But at the beginning of the deposition, Your Honor, they could have said, we're here and reserve on our lack of personal jurisdiction over the Billy Spivey matter.
Well, did they know that that case was even filed against them?
There was, it was notified, that case was stated in the notice, Your Honor, and they're
It was in,
obligated.
oh, it was in the deposition notice.
Yes, ma'am. Yeah.
Okay.
Yeah, they hadn't been served. I agree. We did not meet the 1-year deadline. And
You're
the only-
saying because they were aware of it and they were noticed on the deposition, they should have specifically said that they were not there for that case.
Sure, you always object to objections of a notice at the beginning of the deposition. Otherwise, they're waived. At least that's the way I understand the rules. And
And why doesn't it matter, though, that this deposition notice was more than 2 years after the complaint was filed?
other proceedings were going on in the case. There was there's a lot of other matters going on in the case. Apparently not involving Christ Hospital directly. At least they didn't file anything that I saw that participated there or needed their involvement. The first time that they were involved was the notices of depositions of these two physicians, Dr. Melhorn and Dr. Abagabi. They appeared, they asked questions. There was no statement in the beginning of the deposition that there was any reservation, limited appearance, special appearance, however it is described. They didn't reserve any rights. They proceeded as if.
Mr. Winter, I don't think I heard you answer Judge Krause's question.
I'm sorry. Could you repeat it one more time and I'll give it my best shot?
Why does it not matter that it was past the 1-year deadline?
Well, because there were other proceedings going on in the case, not involving Christ Hospital. But we didn't need to notice the depositions of these physicians until other matters were resolved. There are other issues pending in the case. Motions were filed. And I can't give you, Judge Bach, every which motion discovery request was done, but we weren't ready to depose these two experts until June-ish of 2018. And they were in the case. There was no motion to dismiss for lack of jurisdiction and brought up. In fact, it was Judge Schweikert himself after these depositions were taken and filed that he emailed Ms. Mitchell and my predecessor and brought the issue to a head. And that, in fact, was after the adoption of Civil Rule 3B, providing for the concept of limited appearance. And no limited appearance had been filed by Christ Hospital in this case. Unlike another hospital in the case, Children's Hospital, who had filed and expressly stated that their appearance, they didn't use the word limited, they used the word special, but it was certainly within the spirit of newly enacted Civil Rule 3B. And that.
Can you cite us? I know you cited a case, I think it's called Mary Hugh, but that particular case, the court was trying to determine waiver, but the appearances occurred within the 1 year. Is there any case that you can cite us to where a court has found waiver where the appearance, like in this case, occurred after the 1 year passed?
I cannot right now, Judge Krause, but if you give me a page and a half of brief, I will give you book chapter and verse of cases that occurred outside of the 1 year, if any.
Because I don't know if I didn't see that in your brief, and I haven't found any myself. So I was just kind of curious because this seems like a unique situation where you're asking us to find waiver after the 1 year.
I mean, that's the purpose of the whole request from this court is whether, I mean, we did not serve them obviously, but we're asking for waiver and it can be outside of 1 year. I don't think the Berryview versus Yovick statement of the law on this quote on this case requires the waiver to occur within the 1 year. Although in all fairness, it doesn't say that it cannot or can be, must be within the 1 year.
It didn't really deal with this issue.
It was just a statement of the law, Judge. At their number paragraph 4, or Westlaw's paragraph 4. It just stated what the law is. There are other cases that I discussed that dealt with the taking of a deposition, and once in the Eastern District of Pennsylvania. There was one or two in Ohio, but the facts escape me. I'm sorry, I can't cite you to the book, chapter, and verse on those. If you give me a page or a page and a half, I will cite to you those cases, and if they don't fall within the year, I will so indicate.
Attorney Winter, can you
Yes,
share
ma'am.
with us your perspective, any policy reasons as to why a waiver after 1 year, particularly when the defendant has not moved for dismissal, why a waiver with after 1 year should be accepted by the court?
They participated in the case.
I'm saying from a
for 1 year.
policy perspective, is there any policy reasons that you would support that with?
Sure, it involved in the participation in the furtherance of litigation, which is what the court pushes us all the time on. We want to move these cases along. And it did not move to dismiss. We pressed on for depositions, albeit outside the 1 year. We followed up with a discovery motion directed against Christ Hospital. It responded, and then that occurred in June-ish of 2018 or shortly thereafter. And then they filed a motion for contempt against my clients, my predecessors, and a law firm.
And the motion of contempt, just for clarity, that was filed before any dismissal or discussion on dismissal. Is that right? Or was there already a discussion of dismissal at that point?
I believe there's a discussion on dismissal, Your Honor. The motion for contempt was filed approximately April 15th of 2019. And Judge Schweikert sent his email to the attorneys, as I recall, on October 18th of 2018. And then shortly after, my predecessors below followed up with memoranda as to why the court should exercise interim or impersonal jurisdiction over Christ Hospital. So that occurred, those activities occurred before the filing of the motion for contempt.
Okay.
I think I've indicated that
Attorney Winter, do you want to wrap up?
the only thing I wanted to say was at page 3 of my reply, I talked about Judge Walker's reliance upon the quantity of activity of Christ Hospital in the 2 depositions. And I would just follow up and say, well, of course, they aren't going to ask too many questions because all the good questions have already been asked and answered. But I would ask that the case, that the judgment be reversed and the case cause remanded back to the trial court for further proceedings. Thank you
Okay.
for your attention, judges.
Thank you. Attorney Mitchell, good morning again.
Morning, Your Honors. Just to briefly recap, we believe that the trial court's decision to dismiss this case sua sponte was appropriate in all regards and shouldn't be disturbed on appeal. I do believe that there is a lot of clarification, I think, around some of these issues that would give the court some additional meaningful guidance. This is another one of the Durrani cases in which a party was joined in multiple lawsuits, and involved in multiple duplicative lawsuits around the same time. And this would pertain to Mr. Spivey's claims. And let me just give you a little bit of a recap. Mr. Spivey's claims were originally filed as part of the Bachman mass action involving 36 individuals in January of 2014. That lawsuit also was never served on the Christ Hospital as to Mr. Spivey. It was thereafter dismissed in March of 2015 and voluntarily dismissed by the plaintiffs. That Bachman lawsuit was refiled on March 1st, 2016, also naming Mr. Spivey as a plaintiff. And then this Bayless lawsuit was filed in May of 2016, never served on the Christ Hospital. So this all happened, and the Bayless lawsuit involved Billy Spivey, although they called him Bill Spivey in the Bachman case, they called him Billy Spivey in the Bayless case. But this Bayless lawsuit, this claim in the Bayless lawsuit by Mr. Spivey was the only claim in that lawsuit involving the Christ Hospital, and it was never served on the Christ Hospital. So that Bayless lawsuit proceeded for a number of years, simultaneous with the Bachman lawsuit in which Mr. Spivey was a party.
But ultimately, there wasn't a motion to dismiss that was filed by the defendant after 1 year period had lapsed without service.
No, Your Honor, we did not. And we were never served in that case. It was a case that was one in which we weren't actively involved at any point in time. I certainly never appeared.
So I'm not sure what you're saying. Are you saying that that your client was not aware that they were party of this lawsuit?
No, we were aware of the lawsuit. We were also aware that it had never been served. And
Okay.
we never made an appearance or took any active part in that Bayless lawsuit. There were mass filing requirements in place at that time. So motions on whatever issue that would be filed in other cases in which we were actively involved appeared, as Mr. Winter says, in the docket in this Bayless lawsuit. Again, though Christ Hospital was never served, never actively involved in that lawsuit, and I think as the court made abundantly clear, had every right to attend those other depositions and file those motions in the cases in which it was actively involved at that time, including the Bachman case in which Mr. Spivey was an active party.
Attorney,
So we already had a lawsuit.
would you agree that your client had an opportunity to file a motion to dismiss after the 1 year period had lapsed, well before anything of the nature takes place, the motion for, the motion that was filed by your client, the deposition that was requested by the plaintiff, well before that, would you agree that your client had an opportunity to file a motion to dismiss?
I mean, yes, according to the rules, and and we cited that in our appellate brief, which was the first time we actually appeared in this Bayless litigation in any affirmative manner. In fact, as the cases progressed and in all but the claims of Mr. Spivey were dismissed in August of 2018, the court inquired of plaintiff's counsel what was going on with the Spivey claims against the Christ Hospital in the Bayless lawsuit, because that was all that was left. So there were multiple times in which we were in front of the judge. At that time, he was inquiring what's going on with this, and I would be sitting in the courtroom and say, we've never been served with that lawsuit. We've never appeared in that lawsuit. He has these other claims brought in this other litigation. I'm not sure why they haven't served it, but we've never appeared. We haven't been served. And he said, well, and then they said, well, these hearings went on. And so the judge himself said, I'm going to try to take care of this. I'll get an order out eventually. And that didn't happen until I think started in the early of 2019, where it kept coming back up on his radar every time we were at a hearing, because this was the one portion of the case that was left unhandled. But the Bachman case was dismissed on its merits, in October of 2018, right around the same time. The judge then sent a message to the plaintiff's counsel and to me asking me, had we ever been served in the Spivey case, to which I responded and said, no, we had not. And the court thereafter later took it sua sponte and dismissed it.
Attorney Mitchell, maybe you can help me with this, because this is one of the things I'm struggling with. In a situation like this, if a plaintiff files a complaint and the statute of limitations, within the statute of limitations, and no service is had, no motion to dismiss, the defendant basically avails themselves to the proceedings, in effect, arguably waives it. And then after availing themselves to the proceedings, the case is dismissed, whether sua sponte or by motion. If at that point the statute of limitations has run, it seems to me that it's not a good policy reason to say, hey, you can avail yourself to the litigation and then still benefit from a dismissal thereafter.
I would say the Christ Hospital did not avail itself of this litigation. There were 100 other pieces of litigation pending involving the Christ Hospital in which it did avail itself of the litigation. This was not a case that was on the radar, for be it good, bad, or otherwise of the Christ Hospital because it had never been served.
Can I ask a question about that though?
Yes.
All right. So what I'm trying to understand is that the deposition notice that went out in multiple cases, Mr. Winter said included this case on the notice. So at that point, it would be on your radar, right?
It wasn't on my radar with respect to that case because Christ had never been served in it. It wasn't one we were actively monitoring or actively filing it. Other parties were involved in that litigation and it proceeded in a number of manners in which we were not involved at any point in time over the course of those 2 years. All of the other parties appear to have filed motions to dismiss. We never appeared. We were never made aware of any of those filings in that case because we never filed a notification form in that particular case. So
but I think what Mr. Winter is saying is that at the beginning of the deposition, you should have said, okay, we are not here on this case.
So I did not do that, nor did my colleague at the second deposition, but I think the court made very good points in its decision and the pointing to having an obligation to make some sort of notation on the record. We asked no questions about Mr. Spivey or his claims. We asked very few questions. We attended a deposition in a case in I think 10 cases in which we were actively involved at that time, despite the fact that we had motions to dismiss pending on the statutes of limitations issues. I think further to Judge Zayas' point, though, on if this was filed within the statute of limitations, this case was never filed within the statute of limitations. I think as this court is well aware, even its original filing back in 2014 would have been outside.
That would be an argument specific to this case. I'm talking about from a policy perspective. If the issue before us is whether a waiver can be effectively done after the 1-year period, before any motion to dismiss is in play, then from a policy perspective, it seems that it would be a bad policy to say, no, you can't waive, and allow for a party to be engaged in a proceedings and then do a dismissal saying, oh, you can only have waived within the 1 year. At that point, with some of these cases, the statute of limitations would have run.
I think that as a policy matter, if we were to have appeared and actively participated in the litigation as some of the cases that were cited by the plaintiffs indicated occurred, the decision might be a little bit different, but here that didn't happen. We weren't appearing on behalf of.
Help me with this, because a motion, Attorney Mitchell, a motion for contempt was filed by your client. How is that not actively participating? That's a motion upon your request.
It was a motion filed not on my request in this particular case, and it was filed in 2019, well after the 1 year, which I agree with you, the conduct outside of the 1 year should not affect a waiver, per the rule and per the case law that supports the rule. That motion again was filed. We had a mass filing requirement that plaintiffs availed themselves of, and that every party in this litigation availed themselves of at that time. Christ Hospital did not file that in this litigation. However, other parties did. So the other parties that had been served in the litigation filed various things in this litigation from time to time, in which we also joined for purposes of other pieces of litigation. And that's the way these filings were being done at that time. We filed one Exhibit A for all. And that the filing, again, the Christ Hospital never appeared in this case. It would have filed a motion to dismiss, and it would have been granted along with all the other 96 of them if ultimately we had been served. So again, it's not a matter of it was a matter of we weren't served. This one was not on the radar, and we were moving forward with all of the other ones at the time. I think the judge recognized that we had an obligation and duty to appear and protect our client in the other pieces of litigation that were then pending, in which we were properly served, and that doing so did not waive service in this one other piece of litigation, a second lawsuit by Mr. Spivey.
Attorney Mitchell, just for clarity, to make sure, because, you know, to make sure that I didn't miss anything, with anything that you engaged in before the dismissal, whether it was, you know, like the deposition, which is something that would have been initiated by the plaintiff, or the motion for contempt, which would have been initiated by your client, with any of these matters, was there ever a statement that you were preserving the matter of personal jurisdiction?
With respect to, no, Your Honor, it wasn't, because again, like I said, at the time, this Bayless matter involved multiple plaintiffs, only one of whom was Mr. Spivey, who had another lawsuit pending at the time in a separate piece of litigation.
Made that statement saying, as to the Spivey matter, we preserved the issue and assert that we don't, that there is a lack of personal jurisdiction.
Right, we did not do that. It was not on the radar at all, Your Honor. This case was not ever on the radar with respect to any of the other things that were going on in the litigation. Again, the depositions were noticed. We attended very, very few things, quite frankly, that were on the, that were even part of discovery in these cases, because of Christ Hospital having pending motions to dismiss on the merits in every piece of litigation. So only where we were invited to these couple of depositions did we actually attend. And I believe this may have been one, if not the only deposition in these cases that I even went to. My colleague went to another one, solely because we wanted to preserve our rights in those pieces of litigation that we're moving forward. Again, Spivey's name was also not on the, this was Bayless. And I knew Bayless wasn't one of the plaintiffs against Christ Hospital. So if you've got a laundry list of cases, it didn't trigger that there was one unserved party in a case by a different party's name that I needed to speak out about at a deposition in a case in which we've not been served. And I think that the trial court, did a very good analysis of these issues in the cases in the civil rules, and finding that our actions taken in the context of the mass tort filing process that had been implemented for these cases did not act as a waiver and should not act as a waiver of service in this.
So it sounds like you're asking us to do a rule that's specific to mass tort cases.
I'm just saying that the reason why the filings occurred in this case was because of the filings actually being filed in other cases. So they would just flip onto the docket in this case without even intentionally being placed there, and certainly not intentionally placed there by me, because I was not appearing in that case. And when it got to 2018 and this case came up and the judge started requesting updates on the case, and we realized this is one we've never been served with, we've never been part of, in 2018. Then again, they started saying, well, and they brought these arguments up to the trial court verbally in advance of any filings on these issues and said, you know, the Christ Hospital has gone to depositions. And so at that point, I certainly wasn't going to take any active participation in this case, and didn't, even when the judge invited them to make some filings relating to the why they hadn't served the complaint, or why they never even requested. They didn't even ask for a summons. If you look at the docket, they never even requested a summons be issued.
Can I ask you a quick question though? If you had knowingly participated after the 1 year, maybe you didn't realize the 1 year had passed, and then you showed up and you defended this deposition, but the 1 year had passed.
Mhm.
Would you be able to say, well, wait, we didn't waive because our participation was after the 1 year, and then still move to dismiss the case? I mean,
Not on that ground, I don't think, Your Honor. I think you make a good point. We never actively appeared in this case.
but
I
is
don't
that
think
what you're
I
at?
could
Is that
say-
about the 1 year, right? I mean, so
Right.
if your argument is that this was a mass filing situation and you were not appearing at that deposition for this particular case, but if you had appeared, even though it was after the 1 year, you're saying that then could constitute a waiver?
If I had appeared
If you
in-
had intentionally appeared for this case, maybe you didn't realize the 1 year had passed. They hadn't served you within a year, but you did participate for a deposition after the 1 year. Because that's what Mr. Winter's saying. He's saying the waiver doesn't matter whether it's within the 1 year or after the 1 year. You can waive after the 1 year. Are you agreeing with him that you can waive service after the 1 year passed?
No, I'm not. And if you look at the brief and the way that we argued, I think that the 1 year was the 1 year. And they didn't serve it within the 1 year. And there's actually, if you look at 4E, Rule 4E, I think you could make the argument, and we did in our brief, that they had to do it within 6 months and didn't do it. So for all intents and purposes, this was a dead case by the time, for over a year before we even went to any of these depositions.
So it doesn't, I mean, even if you intentionally appeared on this case after the 1 year, you're saying that could not be considered a waiver.
I don't think that I think it's different because it's hard to say. Yes, I think that's what the case law would support. It's a very strange set of circumstances we've been in these cases. I was so intentionally not appearing that I would be in front of Judge Schweikert saying, Your Honor, my hands are tied here. If I speak out in court as counsel for the Christ Hospital on the record in this case, they'll then argue that was a waiver. So I was really between a rock and a hard place anytime he'd bring this up for the better part of a year, which you can see is reflected in the time period between October, and he started bringing this up even before that. And when he ultimately did anything in July of 2019, because we would go back into the court and repeatedly he'd say, counsel, this is still here. What is this? And I'd say, Your Honor, yes, I'm counsel for the Christ Hospital, but I've not appeared in that case. Christ has not been served. And even when he asked for briefing, and I could have then responded in support of Christ, and I did get served with a copy of that briefing, we didn't respond. We didn't do any filing. In fact, we intentionally did not appear from mid-2018 forward, so that there was no question of our position, which was that we've not been served. We've never actively appeared in the case, never appeared in the case.
And maybe I misunderstood. Didn't your motion for contempt include Spivey?
If the motion for contempt included Spivey, remember that was a joint motion, and it was filed on behalf of multiple plaintiffs in multiple cases, multiple parties and defendants in multiple cases, including Good Samaritan Hospital, that was also a party in this litigation, Durrani. And so, again, the motion for contempt was not directed at this case. If it was ultimately filed in this case, it was done so unintentionally by Christ Hospital, which it was filed. But the intention was for it to be filed in the cases we were actively litigating.
Well, I don't know that we can, make any note whether it was intentional or unintentional. It occurred or it didn't occur.
So that occurred in 2019, I believe. April of 2019, around the same time period, and it was more than 3 years, I think, after the complaint was filed. So again, this case, I would argue was dead at that point as to the Christ Hospital, even though some filings inadvertently were made in it. And that happened this is going too far afield for purposes of this oral argument, but that happened in lots of cases on both sides of the coin, from plaintiffs and defendants, when filings would be filed in all Exhibit A cases and find their way into dockets they shouldn't have.
All right. Well, thank you for your argument this morning, unless there's more questions from the panel.
I have one
believe
more
there
quick
is.
question. Ms. Mitchell, are there any other cases that you could find where a trial court sua sponte dismissed a case based on lack of service after the 1 year period?
I don't know. Again, if you look at our brief, we addressed that issue. I don't know about a sua sponte ruling by a court in that instance. I do know that, I just make one additional point that, this concept of us having a requirement to make a special appearance, they're citing a 1927 case that was issued 50 years before the rule and is not a part of our civil procedure at the present time, so that we should have made some sort of special appearance in those cases. I just argue that the cases that they cited are outdated on that point as well. But no, in terms of the court sua sponte, the cases that we had found, we've cited in our brief.
Thank you.
Thank you, Your
Thank
Honors. I believe the court decision of dismissal should be upheld on appeal. Thank you.
Thank you, Attorney Mitchell. Attorney Winter, you have your 5 minutes.
Thank you. I won't take 5 minutes. The issue here is whether the Christ Hospital's behavior over the wand of jurisdiction here is inconsistent with the relief they sought from the trial court. They appeared at depositions without any
Mr. Winter,
reservation.
I'm going to interrupt you for a second.
Yes,
Ms.
ma'am.
Mitchell is arguing that at the 1 year point, when Christ Hospital was not served at the 1 year point, the case was dead. It was a dead case at that point. How do you respond to that?
No motion had been filed. No, that had to be brought to the court's attention. The case was alive for it to participate further on down the line, which it did. It did so by participating in discovery depositions in this case, and it did so by seeking affirmative relief against the plaintiffs, their attorneys, and a law firm. They sought relief, and that's a waiver at whatever point in time it is. Those activities are inconsistent for the lack of trial court's jurisdiction over Christ Hospital. And did I answer the question?
You did. Thank you.
Thank you. I tried anyway. I don't, judges, if you have anything else for me, I'm done with my presentation. I've said all I have in both oral argument here, and I ask that the judgment be reversed and the case remanded.
Unless there's any further arguments from the panel, we thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision, and have a wonderful and safe week. And that
Thank you,
concludes
judges.
Thank
Thank
you.
you.
That concludes our arguments for today. Thank you.